Hello, everyone, and welcome to the last in the mini-series of webinars that we have organized here at the Center for Climate Change, Energy and Environmental Law on litigation trends in the climate emergency. I'm Annalisa Savaresi, and I am Associate Professor in International Environmental Law at the Center, and I've co-organized this series together with my colleague Kaisa Huta, who you see here on screen together with me. A few words about the series, although being the third, you probably are familiar with it already, but just to remind you, the center is in the middle of nowhere in Joensuu, Finland, and we are very fortunate to be a very large and growing cluster of researchers in environmental, energy, and climate change law with a very large number of both senior and junior scholars specialized in this area. And the webinar series is really aimed to showcase the research that we do and the work we do in collaboration with others. So in this context, the webinar series was engineered to showcase some of the papers that were included in a special issue of the Journal of Human Rights and Environment that I co-edited with my colleagues, Margaretha at the University of Pisa and Joan Scott at the European University Institute. This is the third in the series, and what the special issue and the series did was really to look at the role of human rights in climate change litigation. So in the first webinar, Joanna Setzer from the London School of Economics talked about global trends in climate litigation and the coming of just transition litigation as a new concept that we fleshed out for the first time in that paper. In the second episode, we had colleagues from the Urgenda Foundation who presented Urgenda-style cases and strategic climate litigation. And today, last but not least, we have the fantastic Margaretha Wewerinke-Singh, who needs really no introduction for her excellent work on climate change, law, and human rights. She's, of course, based at the Leiden University, amongst the many things she does, and she's going to tell you more about her work in a minute. She has written a contribution to the special issue together with Sebastien and Jodoin, who also needs no introduction, at McGill University, and two brilliant youth activists and students at McGill, Larissa Parker and Juliette Mestre. Margaretha is here representing all the authors, and she will talk about this overview of Youthled climate litigation. She will have a discussant, Martine Dup, has kindly agreed to be with us today as a representative of a real youth climate activist. So Margaretha and Martine will engage in a discussion, and I will moderate the discussion with you because I really hope that you have questions for our excellent speakers. So type them in the chat if you will, or raise your hand when Margaretha and Martine are done with their presentation, and I'll do my best to capture all your interventions and give you the floor if this is what you prefer. We have about an hour, so I'll stop talking and give immediately the floor to Margaretha. Margaretha, please, the floor is yours, and I'll stop sharing my slides so that you can share yours.
Thank you so much, Annalisa, for inviting us to be here with you today and for organizing this fantastic webinar series, and of course for putting together the special issue. I know it was a mammoth task, but I think we can all say that you brought it to completion very successfully, and as a result, both scholars and practitioners have now this wealth of resources, these amazing papers on rights-based climate litigation. And for me, it's been an honor to make a minor contribution together with my my collaborators, Juliette, Larissa, and Sebastien. So indeed, I'll talk a little bit about our paper, but I will not talk for too long because I'm sure that most of you will be most excited about what will come afterwards, which is the discussion with Martine van Doppen, a leading climate activist who is engaged in the Shell case as a youth plaintiff. So I'm sure you all will want to hear from her about her experiences in being engaged in this case and her vision on climate justice and youth-led litigation. So let me see how easily I can share my screen with you. Okay, here we go. Can you all see the slides? Fantastic. Okay. So what I'd like to do with you in the next few minutes is talk a little bit about the agency of youth in climate justice activism and litigation, then assessing how courts around the world have responded to different types of youth-focused climate lawsuits, and reflect on the implications of these outcomes, these judicial outcomes for children and youth, as well as for intergenerational equity. So, of course, we are talking about a bigger trend of climate litigation. We have more than 1,800 cases that have been filed in more than 39 jurisdictions around the world, most of them in the United States, but many also in Australia, and an increasing number also in Europe and also in the global South. And then as part of this trend, there is what Jacqueline Peel and Harry Osowski have called a rights turn in climate litigation. So we have an increasing number of cases that draws on human rights as a legal basis for trying to hold governments and so increasingly also corporations to account for action or inaction that contributes to climate change. And what we're talking about today is youth-led climate litigation that is based on human rights. So we're looking at this trend and then specifically at the cases that have involved youth as plaintiffs. So why is this so important, this particular subset of rights-based climate cases? It's of course because what is at stake is intergenerational injustice. There are many things that can be said about this, but just to highlight a few dimensions. First of all, children and youth are disproportionately impacted by climate change already today. So here on the picture, you see, for example, a family that's faced destruction of their home following a Category 5 cyclone that hit the Pacific in 2015. This picture is from Vanuatu. The family lost their home, their livelihood. Many children dropped out of school. And even today, 7 years later, many of those children haven't even rejoined school. And of course, since another Category 5 cyclone has struck the Pacific, so Vanuatu, for example, faced Cyclone Harold in 2020, which again caused huge devastation. So children are in a way going from one disaster to the other, are growing up in a permanent state of disaster as a result of climate change. And then children are particularly vulnerable because of their needs, educational needs, but also their physical, of course, vulnerabilities, especially young children. Young children are more affected by health impacts of climate change, and also face increasingly severe impacts throughout their lifetime as climate change impacts go worse. Today's children will still be around a few decades down the line, and then these impacts of climate change will certainly be more severe. And of course, the extent to which they will be more severe, or how bad it's going to be, depends to an extent on the actions that are taken today. And here's then the third dimension, that of representation. So children are most affected by the impacts of climate change today and in the future, but have very little to say about the way in which it is being addressed. So there's a denial of agency. Children obviously are not allowed the right to vote, and their interests are often marginalized. Now, to what extent can litigation do something about these injustices? First of all, what I should clarify, there have been 32 cases, youth-led climate cases based on human rights that have been filed in 14 countries. So we have looked at this set of cases, and to our knowledge, it's an exhaustive study that we have done. So there are no other cases than those that we have studied. And we have drawn on literature that looks at litigation as a way of challenging or questioning the scripts of hegemonic powers and institutions. So here, this litigation, this literature shows how litigation can be a form of disruptive dissent. And here you see, for example, a youth plaintiff who is involved in the Juliana case, being at an event where he's able to share his story about why climate change matters to him and why he has decided to go to court to challenge the United States government inaction on climate change, or at least its lack of sufficient action to protect his rights. And I'll say a bit more about that case in a minute. So what is really striking when you look at the legal outcomes of these cases is that most cases, that is 20 out of 23, have been dismissed at the procedural stage. At the domestic level, that is mainly because courts find that the matter that is being brought to them, and the substance of the case is not justiciable, or because the plaintiffs are found to lack standing. There are very few cases that have been heard on the merits. Then there are few successes, I'll discuss them. There's also one case that has been heard at the merits and was dismissed, and that is the Arctic oil case that was filed by Greenpeace Nordic and youth plaintiffs in Norway, and that is now has been brought before the European Court of Human Rights. So at least that is not yet a final outcome. But in that case, the court did find that the case was justiciable, but found that essentially that the state still had sufficient opportunity to prevent the violations that were alleged to happen, so the harm was not imminent in that case, according to the Supreme Court of Norway. But then again, the plaintiffs disagreed, and we'll see what the Strasbourg court has to say about that. But before the Strasbourg court will hear that on that case on the merits, if it will hear it on the merits, there will be a decision on admissibility. So it is really still, it remains to be seen whether that hurdle of admissibility will be crossed by the plaintiffs in that case. What is also interesting to note is that even though most of these cases have been dismissed, many courts have made some promising pronouncements on the substance. So they dismiss the case, but not without saying something nice and interesting that future cases can potentially draw upon. So I'll mention a few examples. First, a very bad example. We go a bit from the very bad to the better. A very bad example is the case that was brought by plaintiffs from across Europe and from Kenya and Fiji to the European Court of Justice. And it included many different youth plaintiffs. They claimed infringements of their fundamental human rights due to insufficient mitigation ambition taken in Europe. So essentially it was argued that the EU's climate targets were insufficient to prevent violations of their rights that are protected under the Charter of Fundamental Rights of the European Union. This case was dismissed for lack of standing. So the ECJ said that the plaintiffs were not directly affected by the allegedly wrongful acts. And as if that was not bad enough, the court issued an adverse cost order against the plaintiffs. So the plaintiffs, including the youth plaintiffs, they were ordered to pay the costs of the defendants in this case, which of course has a tremendously chilling effect on environmental justice litigation. So I think this is one of the worst outcomes that we have seen so far in this field. Now, a less bad outcome, but still not a good one, is the outcome in the case that was filed by 16 children, including 3 from the Marshall Islands and 1 from Palau, against 5 state parties to the optional protocol to the Convention on the Rights of the Child, which allows for individual complaints. That optional protocol, as many of you will know, has not been widely ratified. So the plaintiffs certainly have looked, and their lawyers have looked at the list of states that have ratified it and then picked those that are big polluters. That's essentially how the plaintiffs were selected. So in that case, the children, just like in the case that we just discussed, the Carvalho case, the children argued that the states did not do enough to protect their rights against the adverse effects of climate change. And they asked the Committee on the Rights of the Child to recommend that the states not only take more ambitious climate action at the domestic level, but also cooperate internationally and use the political and economic power that they have at the international stage, also as members of the G20, to ensure more ambitious climate action and to take adaptation measures and other measures to protect their rights. They also asked for a greater say in decision-making on climate change. So participation, greater participation of children in decision-making on climate change. Now, then the good part about the decision is that the committee found that it had jurisdiction to hear the claim. And that means jurisdiction is a requirement that must be met as part of the admissibility criteria, which essentially means that the committee is competent to deal with the complaint, and the jurisdiction is also closely related to the question of territoriality, because the words, if the state parties, just to take a step back, state parties to the Convention on the Rights of the Child have obligations to protect the rights of children, to respect and ensure and protect the rights of children within their territory and jurisdiction. So within their territory, it's clear what that means. Within their jurisdiction is less clear. So that has been sometimes interpreted as meaning that essentially this is almost the same as territory. So to say that states have only obligations towards children within their own space of the territorial space, but then slightly more expansive jurisprudence recognizes that states have these obligations to protect children who are within their effective control. And a lot of legal nitty-gritty and discussion about the meaning of these terms, but the committee here, in a helpful and you can say progressive move, referred to the advisory opinion that the Inter-American Court of Human Rights had issued on human rights in the environment, where it was said that jurisdiction means essentially that if a state is able to influence the exercise of rights, and for example, by regulating corporations such as fossil fuel companies within their jurisdiction, then it means that those who are affected by those regulation or lack of regulation will be within the jurisdiction. And so that means that the obligations that extend to rights holders outside of the state's territory. And the committee endorsed that approach. And so it recognized that states have extraterritorial responsibilities to protect children's rights against the climate crisis. So the defendant states here, the respondent states, so Germany, Brazil, Argentina, had obligations to protect the rights of, for example, those children in the Marshall Islands and Palau. So these rights of the children, even though they're very far away, cannot be ignored in the state's decision-making on climate change. So that's in a way, that's a very significant breakthrough, you can say, in rights-based climate litigation. But still, now the bad part of the outcome is that the claim was ultimately found to be inadmissible for failure to exhaust domestic remedies. So the committee recognized the existence of these obligations, but then said that essentially the children should have gone to their domestic courts or domestic courts of the respondent states before approaching the committee with their complaints. Now a nice happy outcome of which is one of the very few, but still very much worth highlighting. That is in the future generations case brought before the courts in Colombia, which ended up before the Supreme Court of Colombia. The court agreed with the plaintiffs, with the youth plaintiffs, that the increasing deterioration of the environment is a serious attack on fundamental rights. And it even went as far as recognizing that the Amazon is an entity that has rights of its own. And that is not even something that the plaintiffs asked the court to do. The court did it at its own initiative. So we see a very proactive court here, willing to be very innovative in its decision making. And then the outcome is also really interesting and valuable. The presidency and the relevant ministries were ordered to create an intergenerational pact for the life of the Colombian Amazon, and that needed to be done with the participation of the plaintiffs and other youth groups, as well as scientists in Colombia. And then the court also maintained jurisdiction over the case, so it kept an eye on how the implementation of the judgment was going. So that is at least a positive outcome. Now to wrap up. So we have talked a lot about the legal outcomes of these decisions, and of course the paper that we wrote was a legal paper. We haven't done empirical research to see what is really happening on the ground in the implementation of the cases or in the process of litigation. But what is clear is that these cases, even if they are unsuccessful, they do provide the plaintiffs with the power to tell their story. So as a result of these cases, their courts are turned into platforms for youth plaintiffs to claim some power and at least to be heard, where their voices are not heard in policy-making political processes. They're at least heard in the courtroom. But many questions remain unresolved, including questions about the delineation, the scope, or actionability of the rights of future generations. And that is in large part a result of many of these cases being already thrown out at the initial stage of the litigation. So procedural hurdles that apparently still block real access to justice for youth plaintiffs. We do see that the judiciary is prepared to learn and innovate. And so as this trend of youth-based or youth-led rights-based climate litigation evolves, we will see to what extent that preparedness of the judiciary to innovate and be creative in its interpretation and application of the law will actually ensure access to justice for youth. And of course, we'll see great synergies there between what is happening on the streets in terms of demonstrations and other actions on the one hand, and then litigation on the other. I will keep it at that in terms of discussing the paper, and now move to the more interesting parts of today's today's seminar, which is our discussion with Martina, because Martina was one of the youth plaintiffs in a case that I have not yet discussed, but that is really one of the most interesting and important rights-based climate cases that has been filed to date, and that is the case Milieudefensie, or Dutch Friends of the Earth versus Shell. It's the first case in which a fossil fuel company was held to account for its contributions to climate change based on the Paris Agreement, based on European Convention of Human Rights, as well as the UN Guiding Principles on Business and Human Rights, which are of course not binding, but they were given in a way legal force indirectly, as the court used them to interpret Dutch tort law. So this is a case that was that generated a lot of attention in the Netherlands, as well as internationally. So we would really be very keen to know from you, Martina, what this case, well, first of all, why did you get involved in the case and what this case meant to you personally?
Yeah, thank you for this question. So I was involved almost from the very beginning in this case. It was actually my first climate action I did in my life, because I finished my studies, I did international public health, and I felt very worried about the climate crisis, and I was very much focusing on my own behavior and changing my life and doing everything I could. And then I found this climate case because everybody could be a co-plaintiff in the Netherlands. So I got involved with Young Friends of the Earth, who was also a co-plaintiff as an organization. And then I was part of the board of Young Friends of the Earth, the Netherlands, JMA, it's called the Dutch name. And so that was actually my first engagement in the climate movement, and it felt super strong. So to me, it personally felt like very strong and very much something like we did all together with many youth groups, with many just Dutch citizens, because it was so the plaintiff, like the main plaintiff was Milieudefensie, Friends of the Earth, together with 6 other organizations and more than 17,000 citizens. So it was like a whole campaign around it. And the campaign was also mainly youth-led, because that's what we're good at, right? Like organizing ourselves, mobilizing ourselves on the streets. Yeah, so to me, it meant a lot. And it was really like the moment when the court spoke out loud that we won. I was crying on the streets outside of the court because we couldn't get in still with Corona. And yeah, it was really like an emotional moment. And I can still like we gained so much power and hope out of this. And it's inspiring many organizations and other people all over the world to do the same. And more court cases are coming also in the Netherlands. So I can't say a lot about this, but there's a lot coming up.
That's very exciting.
Yeah.
And so what would you say, or how would you say this case has disrupted the status quo?
Well, I think it was the first case that didn't ask for money or so, but really asked a company to change their policy. So I think nobody really expected in the beginning that it would become so big. And I think really like many people were talking about it. I think in this case, maybe it was a good thing that it took so long, because then our society could get okay with the feeling of, okay, we're taking a company to court, a company that's actually means for many people a lot in the Netherlands, because it's Shell, it's like Royal Shell, it's so it also has a personal thing for Dutch people. So I think in that sense it really changed the idea that the image of Shell is that they're actually not so good, and that they are really responsible as a company, and they really have a big part in the system change we need. And I think like it really changed the idea of individual responsibility towards responsibility from a company, and the feeling also that we as people are citizens able to stand up and not only consumers of this oil. We don't want petrol or anything, we just want mobility for and I think that's really was the disruptive part, that people started thinking in this system change way instead of individual responsibility.
Yeah, that's a huge achievement. And of course, that discourse of individual responsibility is one that Shell in particular has really promoted.
Exactly.
But that's indeed an immense accomplishment that doesn't even have to do so much with the legal outcome of the case, but it is a change of perception that you have managed to bring about through the litigation. That's so fascinating.
Yeah, and I think it was also very strong that that you could, as a citizen, be part of, like, be a co-plaintiff. and really have this feeling like, okay, I'm taking shell to court now. So and really have the feeling that you as a citizen, there's more than voting alone in democracy, and that these things are a huge part of it. And also I think everything came together in that year, because it was I think 5th of April 2019 when we took them to court for the first time, like a dagvaarding, I don't know the word in English.
Summons.
Yeah, and it was the same year that all the youth like Greta Thunberg got all over the world, or like not only Greta, many others, but like there was so many people on the streets, and it was the first big climate march in the Netherlands, so everything built up. So I think we just were also very lucky in that sense, that there was suddenly so much people mobilizing themselves and others to stand up. Yeah.
Yeah, that's a really important point. That it's not just these cases, but it's part of a much bigger movement.
Exactly. Yeah, and I think the campaign around the case was even more important than the case itself. So Milieudefensie is always like, we work in a triangle. So we do movement building, lobby, and like lobby work, like the case, like really about the theoretical work, and then we do a lot of action. So we make our story visible, and we literally disrupt. We don't do that so disruptive anymore as we did in the past, because we really like, I think one of the biggest disruptive actions of Friends of the Year of the Netherlands was when people were sitting on a plane on the Schiphol and really preventing the plane to coming up. So I think there were like 20 people sitting on the plane, and we wouldn't do that anymore as this more professional NGO right now, but still doing actions. And I think this triangle works very well, that you like really focus on movement building, and at the same time doing this legislation and do the lobby work and doing actions, disruptive actions. Yeah.
Yeah, thank you so much for sharing that. I think that's fascinating, and really goes to show how you can claim power when it's not given to you.
Exactly. Yeah. And also when the court spoke out that we won, that on the day we were biking with a group of young people from Groningen, 200 kilometers during the night to the court. And so this action was like, we were putting it everywhere on social media, and therefore like many people were outside of the court. So, and we had this live connection with the court inside. So when hoe zeg je rechter ook alweer? En ik ben even mijn Engels.
Judge?
The judge, oh sorry. So when the judge spoke out that we won, everybody was yelling on the streets, and she said like, oh, I hear the people outside. So that was really, I think it was already a sign that the movement was so big, and that she knew also. Yeah.
Yeah, exactly. Courts do not operate in isolation.
Exactly. Yeah. Yeah. Yeah.
I'm sure that there are others who have questions for you, Martine.
Yes, indeed. Thank you both for that brilliant introduction to youth-led climate litigation and what has happened so far in the practice. I prompted you to ask questions in the chat, but you can of course raise your hand and ask your questions if you like for Margaretha and Martine. Any questions from the floor? Anybody would like to ask anything? I can think of so many questions myself. So whilst people think about it, I will throw a couple of thoughts at you. First of all, you mentioned that there has been a very poor success rate in this specific type of litigation, and I wonder if you have any thoughts as to why specifically youth-led climate litigation has been so difficult, and what, if anything, these plaintiffs can do in order to overcome the challenges they have experienced.
Martine, do you want to speak to that first?
Yeah, I can try. Well, what I see in society or in the world generally is that we as young people still are not taking seriously enough. And so many people want to do youth participation, and it's also something that they have to do sometimes. So then they just invite young people and they can speak for 2 minutes and they don't really listen, and we are not really at the table. So it's mostly like box ticking, like, okay, we did some youth participation and now it's done. But still, and I still felt it in the beginning of the of my climate engagement, like within Milieudependency and also the bigger climate movement in the Netherlands. And it's really changed the last years, since we really showed that there's a lot of power in our movements, going with many thousands of people on the streets. But before, it was just like, these young people, they still have to study, they don't really know a lot. And we were also within the climate movement not being taken seriously. And then once the movement was becoming bigger, and they really like the media was hopping on it, and like really like, and we were being asked so much from us, like, oh, can you go to this radio show, can you do this, can you do that? And then I was like, and now you're asking us, like, what happened? Why not before? And so it really changed, but still they are kind of using us for media purposes, and still not really, we don't really have this place at the table, and we are not yet in parliament enough. So I was also a candidate for parliament last year, and because there was nobody under 30 in the parliament, in the Dutch parliament, and now there are, I think, 4 or 3 people under 30. So that's good, it's a big change. But then, like, you come there with your story, and then I was put on the list on place 35, which I understand because I don't have experience in parliament yet, but I have my experience as a young person, so that should be enough, actually. And I'm representing young people, and I think that's more important than political experience, because of course I don't have it because I'm young. So yeah, I think that's a big thing, just we're not being taken seriously enough all over the world.
Yeah, and I think this links very much to what I was going to say from a legal perspective, because what you're trying to do is, in a way, challenging the status quo through a system that is very much part of the status quo. So that's true for politics, and that's also true for the courts. So when it comes to procedural obstacles, you see this very clearly reflected. So, for example, you can say that the system, the legal system, is very good at protecting property rights that are, inherently part of capitalism. So if you own a car and somebody makes a big scratch on it or damages it, you can very well go to court, and the court will not hesitate in recognizing that you have standing, you have a personal interest because it's your car. Right? That's no problem, and you will just sail easily through the system with your claim. But if you are there and you're saying that this fossil fuel company is harming my future because of emissions, and it's not only my future, it's the future of of everybody on the planet, and especially young people, etc. The bigger you make the claim, the more it's in a common interest, the less likely you have standing, right? You say it's on behalf of everybody, the court will just dismiss your claim straight away because you do not show that specific interest. And that's just one example. It's for most of these obstacles, actually, you can link it to some part of the status quo that you're actually trying to challenge with your claim. So that means that's why it's in a very creative endeavor, this rights-based climate litigation. You're using the system that is in a way part of the problem to try to address that problem. And so what's the second part of your question, Annalisa, is then what can you do about that? How can you then overcome those obstacles? And there it is, to an extent, creativity and really, I think if it's looking at lawyers, for lawyers to really think very carefully how to design claims that in a very clever way try to address these obstacles. So when it comes to, for example, the Saki versus Argentina claim that was dismissed by the Committee on the Rights of the Child because the committee said, you have failed to exhaust domestic remedies. Now that claim in that claim, the child plaintiffs and the youth plaintiffs, they made some very valid arguments that it was very difficult for them to go and file cases in each of the defendant states or respondent states domestic courts. That would have been very expensive. The plaintiffs from other countries didn't know these legal systems. It would take too long. Addressing the climate crisis is urgent, must be done quickly. They didn't have time to exhaust domestic remedies, etc. But all of these plaintiffs made the same arguments. They were repeated in the petition. They were made on behalf of all of them. And perhaps it would have been easier for the committee to recognize that the exception to the exhaustion of domestic remedies rules should apply. There's an exception when it is really not feasible. There's no real prospect of success, the language, no real prospect of success in going to the domestic court, then this requirement can be waived. So to rely on this exception, perhaps the claim on behalf of the plaintiffs, especially those in the small island states or in developing countries without court systems that can really hold anyone to account who is contributing to climate change, perhaps that could have been fleshed out a little more. In a future claim, you could say that you really zoom into the obstacles that these specific plaintiffs face and show that it's really impossible and unrealistic for them to expect them to go to domestic courts before approaching the committee. That the committee really is their first and last resort in accessing justice for these violations that are alleged. So things like that, really fine-tuning the legal arguments so that they become as palatable or irresistible as possible for these courts could help. But then, of course, there are limits to that, and to an extent, it's also the preparedness of the individual judges or experts to innovate that plays a role. And in the end, there may also be institutional limitations that may require even creating new institutions or innovating at the institutional level to make sure that some of these structural barriers are taken away.
Indeed, I couldn't agree more, Margaretha, with that. And climate law is throwing up a lot of problems that are there and don't necessarily only concern the climate. I think also, especially about future generations' rights and how do we enforce it. I think in this regard, climate change is becoming the Troy horse to really start talking about these issues. What do you think, especially Martina, look at you now, what do you think would be the way to better empower activists like you in the courtroom? You know, what do you think is needed going forward based on your experience?
I think so the people who have power now and who have the money now should also share this. So, and I'm also calling upon the big NGOs like Milieu Defensie, Young Friends of the Earth, like all over the world, Greenpeace, Oxfam Novib. And I think partly they are doing it. So they help young people with their legislations, but still I think maybe they take up too much space themselves. And I think, so if you look to young people, future generations, but also other marginalized people in the world, like indigenous peoples who are already threatened by the climate crisis, people who are living in the Niger Delta, like what Shell is doing there since the 1990s, they've polluted the entire Niger Delta. All the water is polluted. They can't eat from it. They can't drink from it anymore. Every year, 10,000 babies are dying because of the pollution from the oil in the Niger Delta. So these, I think there's a huge overlap between like what's they're not only not listening to young people or future generations, but also to most affected peoples living in those areas. So I think, yeah, being conscious about who is actually having the power and share this power and share the money so that other people can tell their stories and can stand up. And I think also as young people, I think we are better able to connect it to other marginalized groups, but also this, we were talking earlier about that it's very difficult to base court cases on future generations, but this, I think this is also part of our that business as usual is very based on capitalism and on westernized science. Because if you look to, for example, Mapuche communities in Chile and Argentina, like they always think in 7 generations in the future. So like being like being humble to learn from other cultures, I think that would help us a lot. Like through the entire climate movement, I see there's not enough attention for this, and we still stick to our problems of the future, while the climate crisis is now for many people already. So I think as a movement, and as especially the big NGOs who have a lot of power, be humble to learn from other cultures and young people and share their power. Yeah.
Thank you, Martina. Margaretha, is there anything you would like to add on this?
No, I see that a question has been asked in the chat.
Feel free to respond to Rosa. And Rosa has posted a question on the chat saying that Duarte Agostinho is a case pending before the European Court of Human Rights, is ongoing, and she would like to hear what you think of this case, and if you have any updates. We're all waiting for the outcome of this case, but I'll leave you, Margaret, to comment on it, since it's such an important case for us here in Europe.
Yes, exactly. It's a tremendously important case. So we're waiting for the outcome. States have made their submissions. We know that after the courts prioritized the case. What is also really interesting from a legal point of view is that the courts invited the respondents and also the plaintiffs to comment on potential violations of Article 3 of the European Convention of Human Rights, which is the prohibition of torture and inhuman, cruel and degrading treatment. That's interesting because the plaintiffs themselves had not brought up that argument that this right had been violated, but the court is interested in exploring whether there is an Article 3 issue. And that's of course interesting because Article 3 is an absolute, the right to be free from torture is an absolute right. They are very strict, the prohibition is very strict. So the fact that the court mentions that there is a potential Article 3 issue is very significant. And then also another reason why this case is very significant is that it confronts what you can say is the fair shares question head on. So the question of what each what each state should do to meet its mitigation obligations that we now recognize exist under human rights law. So how deep do emission cuts need to be for states to meet their human rights obligations to protect human rights against the impact of climate change? That question is is addressed in the submissions of the plaintiffs by reference to the Climate Action Tracker, which provides a methodology which some say is the best available methodology. It's not perfect, but it provides a reasonable answer to the question of what the fair share of a state's contributions to emission reductions, global emission reductions should be based on the one hand, the global carbon budget in light of the long-term temperature goal recognized in the Paris Agreement, and on the other hand, equity. So that's addressed in that way in that case. And another interesting feature of the case is that the question of domestic remedies is in a way turned on its head in the submissions of the plaintiffs, because what the plaintiffs are saying is that, yes, we recognize that the national domestic courts have a very important role to play, and ideally we would like to go to the domestic courts first before going to the European Court of Human Rights. But before we can get meaningful results from the domestic courts, we need guidance from the European Court of Human Rights, because the European Court of Human Rights needs to make it clear that this is the methodology that needs to be applied in dealing with these cases by the national courts. So that is looking at the climate action tracker, fair shares methodology. And if the court provides that instruction, then all national courts will follow that same methodology, and you get consistent outcomes across cases, because of course there is a huge risk as each court takes its own approach, a risk that you get different standards and then that the results do not add up. And we see that, for example, in the agenda case already. The agenda case is really rightly celebrated globally as a victory for climate justice, etc. But if all courts would apply the same methodology and the same order, the same level of reductions as was ordered in the agenda case by the Dutch courts, we would not get the level of emission reductions that we need to keep global temperature rise well below 2 degrees and to have a good chance of staying below 1.5. So we know the agenda, many different agenda judgments, let's say, would not be enough to prevent climate catastrophe. So that is why a favorable outcome of this case would be very useful.
Thank you very much, Margaretha. That was fascinating. There is another question from Rebecca. She asks, I wonder if arguments based on the principle of the best interest of the child will make a difference in youth-led climate litigation. What do you think of that?
Yeah, I'll say shortly something on that, and then Martina, maybe you can respond. I will respond as a lawyer, and perhaps you can respond from a common sense point of view, because in a way, this principle. So under the Convention of the Rights of the Child, for those of you who are not lawyers, the Convention of the Rights of the Child is the most widely ratified human rights treaty in the world. All states except the United States have ratified it. And one of the key principles, probably the key principle of the treaty, is that states must respect the best interests of the child in any decision that they make. And states, of course, that is governments, and that is also courts, that is every part of the state. Now, this principle has been invoked in some cases, including in the Saki versus Argentina case. And in that case, the Committee on the Rights of the Child also recognized that the best interests of the child must prevail in climate decision making. But whether that is enough to overcome these procedural obstacles is another question. So you can argue that these procedural rules must be interpreted in light of this principle. And then perhaps these principles or these procedural requirements can be relaxed a little bit, because that is in the best interest of the child. But we have not really seen that interpretation being used so far. Martina.
Yeah, I hope so that we can. So what I see is that so all over the world, like basic human rights are being violated, also from children. And but if you ask a person, like, are you against human rights or are you against child's rights? Nobody would say, yes, I'm against. So I think on the end, we can base our court cases upon it, like, very well. But at the same time, they're so, like, we're not doing it. So yeah. I think we are in a time where we become more conscious about all these things. We have social media where everything becomes super visible and the word's being spread all over the world. But I think it's gonna take a very long time, and I don't want to be skeptical, but I think, like, justice won't be reached within our generation. I think we need many generations, like, to really, like, but I still believe in that, like, we have to do everything we can, and that we are gaining a lot of good, like, we are doing a lot of good things, and everything goes way faster than before these days, especially because young people are standing up and we are being heard more and more. So yeah, I think I believe in it and I hope so. Yeah, that will be my answer.
Yes, we have to keep pushing, Martin.
Exactly.
All of us. Antti has a question. What do you think what difference you think the Shell case can make in legal and practical terms? What impact can it have on the conduct of companies like Shell?
Well, I can surely try to answer this question because yesterday Milieudefensie came out with a message that if Shell is not, if Shell keeps on pushing back, that we will finally take the CEOs to court. So then it becomes very personal. And there's also other cases from led by Gianni. He is a lawyer from the UK, by Earth Charter, I think. And they are also taking CEOs to court, so making it very personal. So I think this is the next level. And I think I really believe that this is gonna make a huge difference once not only companies, but also CEOs and board members of these companies can be held responsible. So like what we did with the Shell case, like we can put a lot of pressure on many other companies. So we wrote personal letters to other companies, like what we did with Shell, we are planning to do it with your company too. So you better change your policy right away. And of course it's not working straight away, but it really like puts pressure. So yeah.
Anything you'd like to add to that, Margaretha?
That's a perfect answer, and I fully agree with that. And perhaps just one more dimension to add is these companies are probably not so sensitive to the moral pressure because for them the risks are existential. It's a business model that they're trying to protect. And legally speaking, of course, they must also respect the interests of the shareholders. And then at least if you interpret that narrowly, that means that the profits must be maximized. And so this litigation is very useful in trying to force changes of behavior. And another thing that it does is to show the market in a way that fossil fuels is an increasingly risky business where there's a real risk of liability. And there's also increasing talk about who pays for the costs of climate change. And of course, right now, it's the burden of dealing with the consequence of climate change is mainly on the victims in a way, but there is very much at least discussion about cost shifting the costs towards those who caused the problem. And that is something that makes fossil fuel companies very nervous, and probably every single court case adds to that pressure and also shows investors that it may be wise to shift their investments to other sectors that do not come with this risk.
Thank you so much, both of you. This has been fascinating, and I'm sure that the audience has really enjoyed, and so happy we have recorded this because then posterity can check out what we discussed today and see what the results will be achieved. I have another housekeeping point to make before I leave you all for the day. We have an event here in Helsinki tomorrow. For those of you who are in Helsinki, you're very welcome to join us. Those of you who want to join us online, feel free to do so. You can still register for this event on climate change litigation trends in Europe. It's going to be held in person as well as online. We have loads of people registered, but you're very, very welcome if you want to learn more about what is happening in Europe specifically. For now, I really thank Kaisa for helping me organize this webinar series, Margaretha and Martine for being with us and sharing their experience. And Margaretha is doing so much important work on this and many other related matters. So I'm sure that it's been a privilege for all of us to listen to what you had to say. I thank you very much for listening, and hope to see you all in person soon. Thank you so much. Take care. Goodbye.